Kate Judson, after graduating from Marquette Law School, spent 5 years as a public defender in New Mexico. She then joined the Wisconsin Innocence Project, spent 7 years there. I think Kate, without hyperbole, I think Kate probably can claim, or could if she wanted to claim, the distinction of being the lawyer in this country most expert in shaken baby cases or suspected shaken baby cases, suspected cases of abusive head trauma of infants and young children. She's a longtime friend of Professor Keith Findley at the University of Wisconsin Law School. After he and I and Jerry Buting co-founded the Center for Integrity and Forensic Sciences in 2017, Kate joined now almost 3 years ago as executive director. She heads the staff there now and continues to be primarily responsible for the day-to-day operations of Cifs, or the Center for Integrity for Forensic Sciences. Please welcome Kate Judson.
Thank you so much, Dean. I'm really glad to be here. Thank you so much for having me. I'm going to share some slides. If you just give me 1 second to pull them up. So I'm really excited to talk to you all today. And what I want to focus my talk on is the importance of forensic science reform in the broader context of criminal legal reform. So the Center for Integrity and Forensic Sciences, which Dean introduced you to and I run, we want to ensure that everyone forensic science touches, from police to prosecutors to defendants and victims of crime, lawyers, jurors, and judges. We want to make sure all of these folks can be sure that the methods and conclusions that are introduced in court are reliable and trustworthy. And as the system currently exists, we cannot have this confidence in far too many cases. Comprehensive government reports have found very serious problems with the foundations of forensic science disciplines, as well as the ways in which they are applied. You have, of course, heard about cases in which a person was convicted of a crime they didn't commit, right? And the well-publicized exoneration cases are often DNA-based. And although most cases in our system don't include DNA, it still has an important role to play. And that's true even when DNA evidence isn't part of an individual case. So I'm going to explain a little bit of what I mean by that. So researchers, when we study wrongful convictions, study them in much the same way that doctors examine patient care gone wrong, or government agencies examine airline disasters, right? Learning about what happened in a sentinel case helps identify wrongful convictions in the future, but more importantly, it helps identify the causative factors. And so that means that we can apply the knowledge from the more straightforward cases, from DNA cases, to other cases, right? The lessons from DNA cases, where it's, I don't really want to say easy, but perhaps easier and certainly more definitive, those can be applied elsewhere. That's important because only a tiny fraction of all criminal cases, it's hard to know for sure, but somewhere around 5% or less, have DNA evidence. So if we could only count on the right result, right, in cases where DNA could be tested and retested, only a tiny fraction of those affected by the criminal legal system could get justice. But what we can do is we can look at the cases in which DNA retesting has led to an exoneration, and then examine the other factors that led to the wrongful conviction, and then apply our knowledge of those errors to cases without DNA evidence. And so those factors, if you're not familiar with them, are official misconduct, false confessions, perjury or false accusations, eyewitness misidentification, and most important for our purposes, faulty forensic science. So before the DNA exonerations, that is the cases in which DNA testing showed a perpetrator other than the person convicted of the crime, many in the system did not believe that these things occurred or didn't understand how widespread they were. For example, people used to believe that false confessions didn't happen, right? They used to think that no one would confess to a crime they didn't commit. But DNA testing shows that people can and do falsely confess. And contrary to what we used to believe, it's not just young people or people with intellectual disabilities or mental illness, that is especially vulnerable people who falsely confess. It can be anyone. People also used to believe that eyewitness identification was particularly reliable, but now we know, and DNA testing is a big part of this, that eyewitnesses are vulnerable to error, especially if investigators don't take care to protect and not contaminate their memories. Similarly, for a long time, we put a lot of faith into forensic sciences that just couldn't be supported. We believed that when an analyst looked at two hairs, for example, under a microscope, that person could reliably match them and determine who left a hair at a crime scene. We believed that fingerprint matches were basically infallible, but those beliefs are not supported by the science. They've led to wrongful convictions and unjust results. And so we really need to find a better way. So faulty forensic science, right? We can agree that it's hurtful. And so I want to talk about who bad forensic science hurts. And I'll focus on three groups specifically. It hurts, of course, the wrongfully convicted. It hurts crime victims and their families, and it hurts communities. If it contributes to a wrongful conviction, of course, it hurts the wrongfully convicted and their families whose lives and experiences stolen from them as a result. They may experience myriad consequences, including violence or death, as a result of the wrongful convictions. So I want to show you this map from the National Registry of Exonerations that shows the number of exonerations in the United States since 1989. So across the country, 2,880 people as of last month, have been exonerated. And exoneration means that a person was convicted of a crime, right? Asked courts for a new trial based on evidence of innocence, though they might make other arguments as well. They received a new trial, and then when they got that new trial, they either won it or the case was dismissed, right? So this map was pulled off the registry a couple weeks ago, and I think there have been more exonerations since then. But here you can see that it's 2,880 as of the 25th of October. And that means that, and of those exonerations, the folks who were exonerated lost 25,874 years of their lives combined to prison. And they averaged about 9 years per case, which gives you a sense of how big the problem is, because this almost certainly undercounts the number of people who are incarcerated because of crimes they didn't commit. Because as you heard, when I explained what it takes to be listed in this registry, it's incredibly comprehensive, right? You have to be convicted of a crime you didn't commit, go through the entire appeals process and a post-conviction process, and then once you're granted a new trial, either win that trial or have it dismissed by the court or the prosecutor. When we look at these convictions, however, that deal with forensic science, the numbers go up per case. So of these folks, 696 of those people have had bad forensic science involved in their exoneration, right? So they were convicted of a crime they didn't commit, bad science played a role in that conviction, and later the case was overturned. Of those folks, they have lost a combined 7,394 years of their lives to wrongful conviction. And as you'll see here, and I think this is important, they average more years lost per case. There could be a lot of different reasons for that, but one reason may be that evidence is particularly powerful. And when judges are sentencing people, they feel particularly confident in a case that involves forensic science. So it gives you a sense of how powerful this is. There are also these other factors that are harder to measure, right? So relationships, of course, can suffer enormously, but wrongful incarceration also affects things like employment, ability to save for retirement, health of the incarcerated person and their family, and so on, right? So faulty forensic science also hurts victims of crimes and their families. This is a picture that includes some photographs of individuals who've been harmed by convictions related to, from wrongful convictions, right? And so one that I want to draw your attention to initially is here on, it's on my upper right-hand side, is a picture of Christy Shepard. She became a criminal justice reform advocate after the men initially convicted of her cousin's murder were exonerated. And she came to view the experiences of exonerees and crime victims as, she says, completely different, but also the same. We have also been lied to, mistreated, and not counted. Jennifer Thompson, a criminal justice reformer, crime survivor, and co-founder of Healing Justice, describes her just crushing, gut-wrenching guilt about accidentally misidentifying her rapist and her journey to healing in the book Picking Cotton, which she co-authored with Ronald Cotton, the man she inadvertently misidentified. These crime survivors and their families live with the knowledge that the actual perpetrator was never caught or caught too late after victimizing others. And like exonerees, there are very few resources available for these folks. In other cases, faulty forensic science might result in additional trauma to a victim who is miscast in the role of perpetrator. And as Dean told you before, a lot of my work previously centered on parents and caregivers who were convicted wrongfully of killing a child in their care. And I want to give you two examples of that are, I think, moving. So that's what happened to Julie Harper. She's pictured here in the slideshow on the lower left with her son, Joel. She was convicted of murdering Joel based on faulty bloodstain pattern analysis, sometimes called blood spatter, and later exonerated when the real perpetrator, a serial killer of children, was found, and he was incarcerated for another murder at that time. Also, what happened to Christine Bunch, who was pictured here next to Julie Harper. She was convicted of arson and murder connected with the house fire and death of her son, Tony, but exonerated when new evidence showed the fire was accidental. It was related to faulty wiring and a kerosene heater. It also hurts communities. Whoops. It also hurts communities. So when someone is wrongfully convicted, it often means the real perpetrator goes free. There are exceptions like arson, where a person is convicted of a crime that never occurred. And researchers study this phenomenon in North Carolina, just in North Carolina, with a limited number of data points. They found that of 36 exonerations, 9 real perpetrators were found, and of those, 6 went on to collectively commit 99 subsequent crimes. So even with those small numbers, the harm to communities is really significant. That's 99 crimes that could have been prevented, likely could have been prevented if the person who was convicted had not been wrongfully convicted. And I bring these points up because sometimes the tension in the criminal legal system is drawn as tension between fear of convicting the innocent and the fear of allowing a guilty person to go free. And what some miss is that when an innocent person is convicted, often a guilty person also goes free, right? So faulty forensic science also hurts the criminal legal system and the cause of justice more broadly. Why? Well, it's because a part of why the system works is that people have faith in it. Its legitimacy is often tied to its effectiveness and fairness. So that is to say, people believe in the system because they believe it can detect and investigate crime, because they can believe it can compensate for the power imbalance between an individual and the state, and because they believe it generally treats those within it equally. Americans generally believe that our system is fair and blind, but that belief is undermined, right, when individuals are wrongfully convicted. Some of those damaged might include jurors who vote to convict a person later determined to be innocent. In these cases, jurors might live with a great deal of guilt about the wrongful conviction, which is what these headlines illustrate for you. So why is there a problem? Well, partly there's a problem because forensic science disciplines, especially pattern matching disciplines, things like bite mark matching, shoe print identification, even fingerprint analysis, were created and developed by law enforcement. Law enforcement officers and agencies see these disciplines as a way to solve crimes. And so that means that these disciplines arose in a particular context, crime solving, right, rather than pure science in a laboratory. This can make the disciplines susceptible to various types of bias. And it means the testing of these disciplines to figure out how to apply them and whether they're reliable hasn't been done in a setting like a university, but rather as a part of law enforcement in a setting where the stakes are high and oversight traditionally has been very low. That doesn't mean these disciplines have nothing to offer, but it's important to recognize how they arose and have the appropriate skepticism associated with how they arose. So by contrast, By contrast, single source nuclear DNA analysis, widely considered the most reliable forensic technique, was developed largely outside the area of law enforcement. Because DNA analysis was developed as a scientific tool, it doesn't have the underlying problems that many forensic disciplines have. And because it's been used in many ways, testing and quality assurance comes from all different sources and areas, which makes the results more reliable. So you can kind of imagine how something like DNA testing is used in not only in solving crimes, right, but also in the creation of medication, the research related to disease, research related to almost all of the life sciences. And so after being tested repeatedly in those different ways and coming to similar conclusions, that gives us more confidence in the results. So how big is this problem? Well, some researchers believe that in serious violent cases like rape, murder cases, the rate of wrongful conviction may be as high as 5%. And some researchers believe that the wrongful conviction rate is higher, perhaps much higher, in less violent cases that carry lower penalties. For example, accused people have pled guilty to misdemeanor charges or lower level felonies simply because they were arrested, couldn't afford to post bond, and the terms of a guilty plea included release. I'll talk about another example of that in a moment. But wrongful convictions are a serious and dramatic illustration of these failings. They're not the only examples, but they are a serious and dramatic illustration of the way that the system has failed people. So some of these problems can be addressed, right, with scientific solutions found through research and data. For example, Jennifer Thompson, the crime survivor who accidentally misidentified the perpetrator of her rape, did so in part because the procedures law enforcement followed in collecting the evidence, her identification, were flawed. Eyewitness identifications remain susceptible to error, but many jurisdictions have adopted rules with strong scientific support to try to help crime victims and witnesses make more accurate identifications. In other cases, justice requires revisiting old convictions to apply new scientific knowledge or address testimony and evidence presented at a person's trial that's now known to be wrong. So an audience like this one has likely heard about the unreliability of bite mark matching and other pattern analysis evidence like shoe print identification and so on. So I want to talk about a source of error that has been receiving increasing attention in the media, which is forensic pathology error. And I'm actually going to skip a couple of slides and I'm going to come back to our founders in a moment. But so here I want to offer for you two examples of forensic pathology error. But I'm going to start by explaining a little bit what I mean by that. So the forensic pathology error that I'm going to discuss today can be separated into two categories, right? False negatives and false positives. An example of false negatives is categorizing a death as something other than homicide when it was a homicide, right? So these errors might include something like a police killing. This is arguably the most famous example currently. And false positives are the opposite, categorizing deaths as homicides when they are not. So there's been so much recent coverage about the false negatives that I want to be sure to touch on false positives today, although I will say both are equally important and tragic. The women pictured here are two of our clients here at Cifs. Both were accused of abusing children in their care, leading to the deaths of those children, and forensic pathology error played a very significant role in both of their convictions. So pictured here on the left is Amanda Broomfield. Amanda's pictured here with her husband the day of her release from prison. She was convicted of murdering her goddaughter, who sustained injuries and died in a tragic accident, a significant and dangerous fall. Because factors related to the little girl's death were misidentified, misunderstood, and incorrectly testified about at trial, Amanda was convicted, and she spent nearly a decade in prison before her release. In a moment, I'll talk about the specific circumstances of her release because I think it illustrates another really serious problem with these issues. The next woman pictured here with her grandchildren is Stephanie Spurgeon, also on the day of her release. Her situation was similar. She was wrongfully convicted of the death of a child in her care, who later was shown to have died through a natural disease process, a really unfortunate, tragic illness that went undiagnosed. And she was wrongfully convicted based on the testimony of physicians, some of whose testimony later turned out to be factually impossible. Both of these women were convicted. Both of them spent nearly a decade in prison. Both of them were released. And it's interesting because this issue continues to gain awareness, right? So I have here on the right an example of an article written by a team of physicians and cognitive neuroscientists that looks at how bias in decision-making can affect forensic pathology decisions. This is not something that we have historically understood particularly well, because often folks who are experts will say things like, imply that they can have their bias educated out of them, which we know is not possible. Everyone has bias. It has nothing to do with who you are or how much you know or how bright you are. You have bias and we can't get rid of it. We can only try to correct for it, right? And so that's significant because in these two cases, both Amanda and Stephanie were convicted entirely on expert evidence. Nobody saw them commit a crime. In Stephanie's case in particular, the child who died had no external injuries, zero. She was later shown to have had just a tragic stroke. And so you can see how, but once a doctor explains to a jury that there's no other explanation other than homicide, that's extremely powerful evidence. And both of these women were convicted based on very similar evidence that we now know to be wrong. It's also really important to examine what happened after their releases. So both of these women have never been fully exonerated. And that's because I suspect of the power of both the prosecutors and of scientific evidence. Both women were offered the opportunity to get a guaranteed result in their case. Amanda was told that if she abandoned her post-conviction litigation, that she could walk free that day. And so given the uncertainty of a courtroom process, she was compelled to accept that. She wanted to go home to her family. Stephanie's situation was similar. We were able to get her out on a new trial motion, but once faced with the knowledge that the prosecutor planned to prosecute her again, and fearful of an unjust result again, because she'd already experienced one, she chose to accept an Alford plea, which is a plea in which a person accepts a guilty plea but proclaims their innocence, which could be another hour. So I don't want to take up all your time with that, but it's really significant, right? So these cases and others like them might rest on more than forensic pathology error. They might also involve problems with effective representation or tunnel vision when investigators narrow the potential suspects too early in a case. And just their cases also bring up just this critical issue in forensic science reform, because the evidence is so powerful that people are often compelled to accept a result that's less than just because of the power of the experts, the evidence, and the prosecutors. So why the focus, right, on these wrongful convictions and old cases? Because they teach us where the problems are and they give us a path forward. By examining the factors that led to a wrongful conviction, we can see where the problems are and apply those lessons forward, even in cases where we don't know if there's been a wrongful conviction. So some of the things our organization is doing about this challenge include consulting with conviction integrity or conviction review units at prosecutors' offices to help them determine how to handle cases with complex forensic science evidence. By consulting with independent groups like private DNA databases to help develop protocols that will result in the protection of citizens, including innocent people and those accused of crimes, and privacy interests, and also consulting with lawyers who have cases involving forensic science questions. We write amicus or friend of the court briefs to help educate courts about complex forensic science issues. We conduct trainings for lawyers and other stakeholders and community groups like this one about particularly thorny issues. And we also bring these groups together to learn from each other. We don't only focus on mistakes of the past, we're also engaged in the development of policies around new forensic sciences so that we can move forward in a more thoughtful and safe way. Part of the issue in the past was that police officers or law enforcement agencies would develop new ways of looking at evidence, but they weren't developed with scientists outside of the typical law enforcement framework. And that's a big part of why we have the problems we have. So we therefore work with scientists and others developing new areas of forensic science. DNA technology, for example, has become more sensitive, right? So more able to identify profiles from smaller and smaller amounts of material and more complex mixtures of DNA from different individuals. And while this can be a powerful tool, it also comes with challenges. More complex mixtures mean additional interpretation. So that can include human factor error. And even though some companies have developed software that allegedly decreases the human factor error, those technologies have their own problems and their own room for error. Plus, some of them have not been developed in a transparent way, which makes them more difficult to understand or to assess their reliability. What's more, as DNA amounts that can be tested get smaller, the relevance of the DNA may decrease due to transfer and other factors. So if I borrow your pen and touch it with my hands, and you touch it, and then you touch a doorknob, my DNA might be on that doorknob, even though I never touched the doorknob. And so for that reason, the National Institute of Standards and Technology has recently released a report urging caution in the adoption of these new testing schemes. They say that more research is needed to develop trustworthy standards for these types of testing and interpretation. And so for this reason, our organization has been advocating for reliable standards and increased safety around these disciplines, including in these new technologies, as well as the disciplines from the past that have been shown to not be reliable. But the point I want to drive home on this particular issue is that just because the DNA label is on something doesn't necessarily make it reliable. It just really underscores, as we've been talking about today, the ways in which wrongful convictions and unjust outcomes represent many systemic factors, not just one. And it's tempting to think about these cases as rare outliers. And while some of them are especially egregious, the systemic failings could affect, really anyone at all in any number of ways. And so that's a huge part of the reason why we are out there trying to get people to understand the shortcomings of these technologies and techniques, and reform that part of the system. And so I know that I'm sure that people have questions. I'm happy to answer them. And I'm also happy to expand on other things and kind of whatever folks want to do.
All right, I'm going to open it up for questions then. I'm just going to see if I can end the screen share, or can you do that just so
I can do that. Yeah, sorry about that.
See everybody? All right, I don't see anybody raising their hands just yet, so I'm going to send it to Gretchen, she's always got some questions, so I will send it to her to kick it off.
In Wisconsin, the state crime lab is in a prosecutor's office. I don't understand that, and I'm wondering if you can comment on it.
Neither do I. One of the strong recommendations of the National Academies of Science when they did their review of forensic sciences that resulted in a big report that was published in 2009, that was a major recommendation that crime labs should be situated outside of law enforcement agencies. I'm sure there are a variety of reasons, including I'm sure ones I haven't thought of, about why that happens. I mean, one is certainly inertia. But yeah, that's been an enormous problem. And it seems to me one that is relatively straightforward to fix, because it would require bureaucratic restructuring, but it doesn't require this sort of comprehensive going back and looking at old cases in a real comprehensive way and all of the issues that entails. So sorry if that's not a very satisfying answer. I don't know either. They should do that.
Do you see any movement that Wisconsin's thinking about changing that?
They did take some steps to some sort of nods towards separation, but I haven't seen any indication that there's a more comprehensive removal of the crime lab from under the executive branch umbrella.
Thank you.
Oh, well, just one thing I would say though about that is that the crime lab has been receptive to some ideas about reform and improvement. For example, one problem that occurs a lot and that's easy to fix, right, is when investigators of a crime bring evidence to an analyst and share facts about the case with the analyst, that can contaminate the analyst's handling of the evidence, even if they do not think that it does, right? So it can contaminate their thought processes in hidden ways. And one thing that the Wisconsin Crime Lab has done that is laudable, right, is have instituted separation between investigators and analysts. So there's now a human being in between those two groups. So investigators bring the case to, I forget what I don't recall that person's title, but there's a go-between, right? And this person hears about the facts of the case. And let's say that there's an allegation that the perpetrator touched a cup, right? Then they might hear that information from the investigators, and they might write a memo that says, what we need for you to do is test for DNA on this cup, right? So it does have that little bit of separation, but it's not adequate to resolving the problems that come with housing forensic science organizations within law enforcement.
Thank you.
Dorothy, do you want to ask your question? I'll read it for you. So you're muted. Okay. Is there a process for notifying the prosecutors experts of the outcome of your work for cases the experts testified about? That's coming from Dorothy.
No, and that's a great question. No, there's no system-wide process for doing that. And that is a huge issue because often the folks who are involved in these wrongful convictions, even after the conviction has been shown to be utterly like terrible, right? They don't get that feedback, or they get that feedback in a situation that allows them to really discount it. And so what I mean by that is they might hear, because the system is so adversarial, they might be vigorously cross-examined at like the expert might be vigorously cross-examined at like a post-conviction hearing, right? And they may not have additional contact with the defense lawyers or the person who's been accused. Their contact is primarily with the prosecutor. And so you can imagine that when cases get overturned, they're then filtered through the lens of the prosecutor, right? And you see this with crime victims as well, unfortunately. Sometimes after an exoneration, the crime victims are primarily speaking with the prosecutors in the prosecutor's office. So they might hear, this terrible unjust result happened, we're so sorry, rather than for a variety of reasons, we understand that this isn't the person who harmed your loved one, for example.
Jim, go ahead.
I'm not familiar with a lot of the criminal law procedures, but I'm wondering where the prosecutor doesn't buy into the evidence that you would present, and you're forced to put your case in front of the judge, and whether through evidence or something else, what's the burden of proof or legal standard that the judge has to apply to make a determination that this is a wrongful conviction?
It varies depending on the state-specific statute. So in some states, it might be clear and convincing. In some states, it might be preponderance. There's also, I can't remember what state it is, but there's somebody, Mississippi, that says you have to refute, that you have to, I don't remember the language, but this, between the statutes and the case law, there are varying levels of proof in different states. And actually, interestingly, varying procedures by which to bring a post-conviction action. I mean, they boil down to you have to convince the judge, right? Yeah. But in general, the technical aspects of it vary. And our organization works on cases actually across the country and in some other countries as well. And it is highly variable. It's a highly variable process.
Thank you.
Dean, go ahead. Oh, you're muted.
Thanks, Margot. Kate, this question in some ways is a little bit tangential to your presentation, but it actually turns out to follow directly on Jim's question. I think one of the emerging problems with discussion of exonerations and sort of acceptance of exonerations, both within the legal system and more broadly with the public, are, I guess, what I would call definitional disagreements. What counts as a wrongful conviction, and even what counts as an exoneration. Is a wrongful conviction limited to cases of overwhelmingly demonstrable innocence, or at one end, or does it also embrace all the way at the other end convictions secured by improper procedure, or constitutional violations resulting in evidence that shouldn't have been admitted, but otherwise was reliable evidence. And I'm just wondering if you're aware of any effort that's been made or is brewing to try to at least propose a lexicon that could be used to describe gradations of cases across the span of legal errors, from undeniably convicting an innocent person down to a conviction that's legally unsound, but not necessarily factually unsound, and everything in between. Are you aware of any sort of lexical effort in that regard that might blunt some of the criticism of organizations dedicated to exoneration?
I think it's complicated because you hate to create gradations of innocence, right? So there are the cases in which someone was unquestionably wrongfully convicted, like DNA exonerations, where you can really almost make although sometimes people do, you can really almost make no argument that that the person was present at the crime scene or committed the crime. And then there are these other cases that we know are secured with the use of false evidence or faulty evidence, but they lack that real certainty that or near certainty that single source DNA evidence can give us. So I think it's difficult, right? I'm quite reluctant to create those gradations. And I'll tell you that even within the innocence community, there's a lot of disagreement about how to process, explain, educate about these issues. There are innocence efforts that are criticized because they also take on so-called wrongful convictions, meaning, you know, there's an innocence effort that has been under fire for taking on cases in which the person was actually guilty, but the sentencing is outrageous, right? Like the Arizona Justice Project has a case in which they were able to secure relief for a man who was convicted as a very young person of a drug possession related crime, possession with intent. Maybe, I'm not sure on the exact statute he was convicted under, but he's sentenced to 50 years in prison. And they came forward and said, look, whether he did this or not, this is absolutely ridiculous. This is wrongful. And then there's other tangentially related, or perhaps more than tangentially related, question of who gets listed in the National Registry of Exonerations. So exoneration has, although people colloquially use it differently, it has an academic definition. And the academic definition generally used of exoneration is a person who, through post-conviction procedures, receives a new trial and then is either found not guilty by a fact finder, a judge, or a jury at that new trial, or the case is dismissed at new trial. The prosecutor or the judge chooses to dismiss the case. And so those are currently the only people who are listed as exonerees. And that's also problematic, right? Because that excludes a broad swath of people who were wrongfully convicted, including those exonerated based on DNA evidence, truly, who chose to end their case through another means for a wide variety of reasons, generally personal. So that's not a helpful answer because it doesn't give you like the real, here's what we should do. But I think it's, you know, like so many issues related to this work, it's incredibly complicated. And I think many of us who are activists looking back can see all the injustices in the places where people were excluded and try to be extra cautious about applying those discrepancies going forward.
I don't know that it is unhelpful, actually. It just suggests to me that maybe part of what those of us engaged in these efforts should be thinking about over time is partially untethering ourselves from the word innocence, and at least opening up a range of topics beyond that, you know, innocence, but also unreliability and maybe unlawfulness, and defending reforms and change as to any of those categories, rather than being accused of trying to lump them all into innocence or, you know, exoneration or whatever. It may just be in part a definitional problem and an opportunity to confront directly that we also need to be concerned about the unlawful conviction. We also need to be concerned about the unreliable conviction.
Absolutely. And that raises another important issue, which is that sometimes people have a presumption of innocence in name only, right? And if we want to take very seriously the right of every accused person to have the presumption of innocence, then that means they are innocent until they are proven guilty, and proven guilty means lawfully so.
All right, please do raise your hand if you have a question or just flag it in the chat for me. And in the meantime, I'll ask one. So Kate, we have what you're doing in the CIFS and all of the advances in learning about forensic science. But then we have a Supreme Court case from, I don't know, the 70s that talks about how, like, the factors to consider for eyewitness identification. And so we have all of these updates in the sciences. And I think a couple of years ago, there was this Wisconsin Supreme Court case that discounted social science as even being valid. So how do we get the standards that we need today into the case law to be considered by, is there education for judges going on? How do we get the changes so we're not relying back to a 1970s case on what eyewitness identification requires?
Yeah, I mean, some of that is judicial education for sure. Some of it, and that can come through seminars, events, publications. It can come through amicus briefs, which we are frequently engaged in, trying to educate courts about the right steps to take before any expert evidence, which could include eyewitness identification experts, as well as, what you would normally call the hard science experts, but what factors they need to meet in order to be considered reliable. But it also, I think, is something that needs to be pursued outside of the courts. I think educating the public about these shortcomings is really important. I think people need to understand where the system can go wrong. And there's, I think legislative efforts are also important. So yeah, of course, educating the judiciary and getting the right results in individual cases that's an incredibly important part of what we do. But getting the message out so that it seeps into the consciousness is important. I mean, if you think about big civil rights advancements, they're generally not led by the courts. I mean, sometimes you have a court at the forefront, but you also have groundswell, you have grassroots engagement, you have uprisings of people demanding the rights that they're owed.
Gretchen, go ahead.
What's the low-hanging fruit here? I mean, is it street drug tests? There's so much wrong with forensic sciences that is there an easy win that hasn't been won yet?
Yeah, we could stop using field testing. That's huge, right? For folks who don't know, field drug testing is the use of these kits that police officers typically carry around in their cars that allegedly allow them to identify controlled substances. They're wildly unreliable. They've been shown to react with all sorts of things, including my favorite, exposure to air. So like just existing can make them give you the wrong result, right? We could stop using those. We could get crime labs out of police jurisdiction, right? We can remove them from law enforcement. We can make sure that when there's discussion about reform, that a wide range of people participates, that criminal defense lawyers are invited to participate. A great example is I'm sure that the folks involved with this would not call this an easy win. They would call it a long and hard fought win. But when it became clear that microscopic hair comparison analysis had led to wrongful convictions, the FBI, the National Association of Criminal Defense Lawyers, and the Innocence Project worked together to generate a report on how unreliable that evidence had been, and how many analysts testified falsely in those cases. The numbers were astronomical. 97% of FBI analysts who testified about microscopic hair comparison analysis either overstated or misstated their results. I mean, we could stop using these techniques that have been shown to be unreliable.
Any other questions for Kate today? In the meantime, Kate, can you talk a little bit about the founding of CIFS?
For sure. So Cifs was founded following the release of Making a Murderer by the lawyers featured in that docuseries, Jerry Buting, Dean Strang, who you just saw, and Keith Finley. And they were responding to something that they had seen in their practice, which was that the courts had not caught up with what scientists had been saying, what hard scientists and government agencies had been saying about forensic science all along, was that it was missing certain markers of reliability that other types of science included. And so they founded the organization in order to help lawyers and courts catch up with the science to end these kinds of disasters, these kinds of unjust prosecutions.
And you're actually representing people as well as advocating, or what are the activities you're doing?
Sure. We have a limited number of direct representation cases, and we consult on far more. We consult on hundreds a year, where lawyers who have questions about the kinds of cases they're dealing with, and both prosecutors and defense lawyers. We talk to more defense lawyers simply by virtue of the fact that most often scientific evidence is being challenged, is being offered by the prosecution. But we also work with prosecutors, especially those in conviction integrity or conviction review units, to help them understand what things they should be looking for when they go to review these old cases that have errors. So we consult on a big number of cases a year, represent clients in a smaller number, and then do things like generate friend of the court briefs for courts considering these issues, talk to community groups. We are also involved in educational efforts at universities. So we're part of a course at the University of Wisconsin that brings together law students and graduate students in the sciences to learn together about these shortcomings and to learn from each other, not just from us, right? About how they can work together to improve some of these outcomes and understand what the other group does a little bit better.
All right. Any other questions for Kate today?
I've got one more.
Okay.
How do defense teams, given that 80% of criminal defendants roughly are indigent, how do the defense teams match the resources of the state to do adequate challenges to forensic science evidence?
Thank you for the layup, right? They can't. They can't. They cannot. It's no matter how many resources a single individual has, they will never be able to match up to the resources wielded by the state. But in order to get better results in some of these cases and try to reduce that imbalance, we can educate lawyers about the importance of thoroughly challenging these issues. We can educate judges about what to look for in making their rulings, and also the importance of resources. So as you know, in many counties, whether or not you can hire an expert witness is controlled by the judge if you're a defense lawyer. So we need to also make sure that folks who are running indigent defense organizations and other people who control the purse strings like judges understand the importance of having a thorough independent review of evidence that's being sought to be admitted. I think that, this is a common problem that I'm sure you have all seen elsewhere in the criminal legal system, which is that defenders are just chronically and across the country under-resourced and overworked. And there are some other reforms that dovetail with not only forensic science reform, but also with other types of criminal legal reform, suggesting, pay parity between defense lawyers and prosecutors, workload parity, making sure that private lawyers who take on indigent defense cases are adequately compensated so that they're able to spend the time that it takes to do those types of cases. There's a lot of reform that will help a number of things that are wrong with the criminal legal system while also contributing to forensic science reform.
All right. Thank you, Kate, for joining us today and for the time and effort you put into preparing for today with the slides and in your presentation. We really, really appreciate it. And for those attending, do look for another salon in mid-December, speaker to be determined or yet to be announced. And again, please do look for our annual appeal mailing. We thank you for joining us today, and we hope you stay safe until we see you again.